Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 221 of the DWI Guy podcast. On today's episode, we are doing a DWI update, a look back at some of the big state cases from this past year from North Carolina, some of the big DWI cases that the courts have released. So we're going to go through a survey of recent cases released from the Court of Appeals and Supreme Court of North Carolina. Before we dive in, I have a story to share with you, and this is a myth, somewhat based on reality, but I want to take you back. Go back with me to the day that you began law school. Close your eyes. Remember that day. Remember even before you breathed in that law school air for the first time, when you reached out to the admissions department. You tried to figure out how to send in an application. Maybe you called the admissions. You went through the process. Maybe you met with the admissions team and talked about coming to school where you went to school. So go back to that space with me. Let's imagine there's a fella named Jake, and he walks into the law school admissions office. And Jake, he's ready to be a criminal defense lawyer. He is ready to start helping people that are charged with crimes fight back against the man, fight back against the state. So he goes into law school, and he is pumped about beginning this journey to a place where he can represent clients in the courtroom. And so he knows that this is the launching point. So he comes in, he looks at the director of admissions, and he says, I want to be a criminal defense lawyer. Can you teach me how to operate a criminal defense practice? The admissions director looks at him and says, no, we can't do that. Can you tell me how to market for my criminal defense practice, how to advertise, to build my brand, how to conduct SEO, how to get Google reviews for my business? Can you tell me how to do that so that I can build my criminal defense practice? Admissions director says, no, unfortunately, we can't do that. Can you tell me how to hire people that I'm going to need on my team? Can you tell me how to bring in people from the community to partake in intake and help me with my office administration and client processes and case management systems? The director of admissions says, I'm sorry, Jake, we can't teach you how to do that. Can you teach me how to build an amazing client experience so that my clients will go out and act as a sounding board to the community to tell everybody what a great lawyer that I am because of this amazing client experience that I have built into every step along the process? The director of admissions is now, kind of looking down at the floor, looking up at the ceiling, and says, Jake, we're not going to be able to do that. So then Jake switches gears a little bit. Jake says, well, how about this? Can you tell me how district court in North Carolina operates so that when I come out of law school, you will, I'll be able to, even if I don't know how to run a business, at least I'll be able to operate, my practice in the courtroom. And the director of admissions says, we don't teach really anything about how district court in North Carolina operates. Well, I'm really interested primarily at this point in doing traffic cases, but really handling DWI cases. Are you going to tell me how to try a DWI case? Are you going to teach me about the intricacies of DWI law? The admissions director is kind of looking to the door a little bit, seeing if there's anybody that maybe she can pull in professor-wise. But she says, as far as I know, we don't have anything in our curriculum that is DWI specific. I don't think that our mock trial program has a DWI type case scenario that is typically used for our first year program. And I don't know if there's any appeals concentration point in the area of DWI as you get further in. But, as far as I know, we don't have a specific course on North Carolina DWI law. Well, could you do something, as basic as explain to me how to read a driving record? Is that something that's going to be taught to me here at the law school? And the director of admissions now is, again, just kind of like, pulling out drawers, mumbling, making a lot of awkward pauses, and says, we can't teach you anything about anything about a driving record. She's kind of lost it because the value of what is being conveyed, since you're interested, you, Jake, are interested in criminal defense, doesn't seem to be going very good in terms of how is this particular institution going to set you up to do that. So then you ask the question that this admissions officer has been so desperately waiting for. She's going to answer this one almost without you ending your sentence of the question, because she's so excited about a question that she has an actual answer to. You say, so what is it that you're going to do to help me on this dream to opening my criminal defense practice? And just without missing a beat, she delivers the line from Paper Chase of Professor Kingsfield. And she says, you come in here with a skull full of mush. You leave here thinking like a lawyer. That's what we're going to teach you. We're going to teach you how to think like a lawyer. Yes, you won't know anything about criminal defense, substantive law, DWI cases, driving records. You won't know anything about how the processes of the courtroom work. You're not going to know how to run your own practice. You're not going to know how to hire. You're not going to know how to meaningfully engage with your clients. But you will leave here thinking like a lawyer. And that sounds nice. You don't really know what that means, thinking like a lawyer. Jake is a little bit lost as to how this is helpful in running a criminal defense practice, but the promise of thinking like a lawyer is there. So you say, okay, well, at least that's, I do want to be a criminal defense attorney. So I guess thinking like a lawyer would be helpful. How much is that going to cost me? And now, again, the person said, well, you're probably going to have to talk to the billing department. You want to talk to maybe get some loans figured out or whatnot, because this is going to be pricey. Probably looking in the neighborhood of about $100,000, depending on whether or not you get scholarships or any type of federal aid, maybe $150,000. And that's kind of where the going rate of it is. And you say, so that's the cost of being able to think like a lawyer is $150,000. And they said, well, that's not all you get. I mean, that's not the only thing that you get when you come to law school. You not only leave thinking like a lawyer, but you also get this really fancy piece of paper with 6 signatures of the higher ups at our school that will then allow you to sit for the bar exam. So if I come here, I'm not automatically a lawyer. No. You're going to think like a lawyer. And then after you get out of here and you pay that $150,000, then you can go sit for the bar exam, and hopefully you pass the bar exam, because if you don't, then you've kind of just wasted your 3 years and $150,000. But hopefully it'll all work out. you study really hard, you take a bar prep course. Is that included in the fee? No. The bar prep course is actually going to be separate. But once you've done that bar prep course and you've sat for the bar and you've kind of lost your brain and you're pooping yourself because you're so worried about how this is all going to turn out with the bar exam results. If you get a letter from the state bar that says that you are admitted to practice because you did well enough on the exam, then you become a lawyer. You can put all that thinking like a lawyer into action. And so, despite the warning signs, you say to yourself, okay, sounds like a great deal to me. And you sign that piece of paper. Jake signs that piece of paper, and off and away he goes into the law school dream, into the space of thinking like a lawyer. Now, that dream may sound familiar to many of you, but that is, to some extent, the journey for some of us as we go into law school. You don't know what you don't know until you get into law school. But in law school, for me personally, I had a 1 hour class that was an elective, a 1 hour class met on Wednesday nights. It was taught by the dean, really great class called Law Practice Management. Took that 1 hour class. It was a pass fail class. It was not a graded class, pass or fail. And I'll never forget the dean explaining why it was pass or fail. And the reason why he said it was pass or fail was because he basically said, if you are planning on hanging your own shingle, if you're planning on practicing, pass or fail is going to happen in real life. You're going to get graded on how this actually translates in the real world. So if you want to put in the time now to prepare yourself for life after law school, great. If you don't, that's on you. But I appreciated that answer. I think that's a great answer. But that was the, kind of the sum total of the kind of academic focus on law practice management. There were some good internships, some other things that kind of allowed that opportunity to see practice in the reality. But really, there is very little in law school that helps us become incredible business owners. And for those of you that are listening that operate a small criminal defense practice, it is a high learning curve that is self-initiated, self-studied, self-taught on how to run a criminal defense practice. And coming in September the 26th and 27th in Asheville is an opportunity to sit down with other criminal defense owners, some that have been doing it for a few years, some that have been doing it for decades, and their legal teams, and have an opportunity to figure out how to operate a better law practice, how to have a better life, because our business is so much a part of our life. The Freedom Fighter Summit in Asheville this September is a major stepping stone opportunity to taking your practice to the next level. And that can mean a lot of different things for a lot of different people. If you are looking as a solopreneur to grow your law practice, you want to operate in multiple locations, you want to have multiple employees, that is your opportunity for growth. This is a conference for you. If you are a law firm owner or an attorney or an admin team member that already has a booming criminal defense practice, but you're overworked, don't seem to have time to answer the calls that are coming in, you've actually got the phones ringing at such a high rate that you're like, I just don't think that this is really something that I need to be working on. In fact, the Freedom Fighter Summit is for you as well, because we're focusing on better systems. We're focusing on AI. We are focusing on ways to streamline and improve your practice so that you put more time back into your schedule. If you love running around like a chicken with your head cut off, moving in a bunch of different directions all at the same time, having multiple phone conversations while you're standing in front of the judge arguing a case, if you love that life, this conference is not for you, because this is about having a better life, a better practice, a better team working better for your clients, being better for your community. That's what this conference is about. And I extend the invitation, which I guarantee you is not going to cost $100,000 to $150,000 down this journey. I guarantee you is going to open a lot of doors and improve your practice in ways that you can't even possibly imagine until you join us in September. Reach out to me if you want to learn more about the summit. Please feel free to send me an email, james@miniclaw.com. Would love to discuss what we have planned for this year's Freedom Fighter Summit. So with that, we are now going to dive into our DWI update. This is the 2024 DWI update, and I'm just going to hit cases in somewhat of a categorical fashion. So I will start with checkpoints. So State versus Alvarez. This was a North Carolina Supreme Court decision, State versus Alvarez. And really why this is important is that the Supreme Court did not overturn the Court of Appeals' decision on the basis of a checkpoint. So the Court of Appeals is really where this case is important for purposes of those of you listening and when it comes to challenging checkpoints. So State versus Alvarez at the Court of Appeals level, and all of these will be in the notes, so I'm not going to give each citation, but State versus Alvarez is a 2021 unpublished case from the Court of Appeals that looks at checkpoint cases. And so the facts of this case are that the Rowan County's Sheriff's Office set up a checkpoint. The checkpoint was purportedly in response to high-speed fatality accident that had occurred at the location 2 days earlier. There's no officers on scene that were checking for speeding at the time of the checkpoint. The defendant's passenger side wheels came off the road and onto the grass prior to stopping at the checkpoint. And one of the officers on scene testified that this behavior led him to believe the defendant might be driving while impaired. So both the trial court, or the Superior Court in Rowan County, and the Court of Appeals found the checkpoint did not have a proper primary programmatic purpose. Really powerful case if you've got a proper purpose question mark when it comes to a checkpoint. The Court of Appeals also appeared to call into question a checkpoint that is set up for all Chapter 20 violations as being overly broad, as basically violating the kind of general crime control limitation on checkpoints set out by Edmonds. So really powerful Court of Appeals decision when it comes to checkpoints and having a proper primary programmatic purpose. The Supreme Court, which ruled in 2023, overruled the Court of Appeals, but it did so on the grounds that there was reasonable suspicion because of the lane violation. So it did not upset the Court of Appeals' decision regarding the constitutionality of the checkpoint, because they said the stop could be based on reasonable suspicion. Checkpoint analysis was unimportant. So look at that Court of Appeals decision. Look obviously at the Supreme Court decision, but when it comes to the checkpoint issue, look at the Court of Appeals decision dating back to 2021. So moving on to our next category, reasonable suspicion. case State versus Peak was decided by the Court of Appeals 2023 case, unpublished. The facts of Peak are that the stopping officer was highly specialized in DWI investigations. The defendant delayed for 10 seconds at a traffic light after it turned green. Couple of open bars within a quarter-mile radius of the stop location. The defendant crossed over the yellow lines with both left tires into the opposite lane of travel and was traveling after that delayed stop at a stoplight at 1 to 2 miles per hour. Holding was that reasonable suspicion existed to stop the defendant. Nothing particularly unexpected about that decision, but again, just putting that out there as a stop case that was published, or I'm sorry, unpublished case from the Court of Appeals. Next, we've got probable cause case, State versus Woolard, and I think that really more than being a probable cause case, this is kind of like a procedural question case of when can the state appeal a motion to suppress. The answer ultimately is basically whenever the heck it feels like. That's not obviously what the ruling says, but that's my interpretation of it. But facts of State versus Woolard, which is a Supreme Court case, 2023 decision. The officer in that case saw the defendant cross the center line 6 or 7 times. The officer activated blue lights, and the defendant quickly responded and stopped. The defendant seemed normal to the officer on initial approach. After asking about the driving, the defendant told the officer that there was bees in his truck and that he was trying to get them out. As they spoke, the officer noticed an odor of alcohol, flushed cheeks, and red and glassy eyes. The officer said that the defendant seemed coherent. He said that the defendant admitted to having a couple of beers earlier. The officer administered 2 portable breath tests, but those were excluded because they were not performed correctly. Officer also got 6 to 6 clues on the HGN test and placed the defendant under arrest. So that's kind of the facts. Now, here's what's really important is the procedural history of this case. So the defendant was granted a preliminary indication that no PC existed in district court. The state appealed to Superior Court, where the defendant again prevailed, and the case was sent back to district court for a final order granting suppression. After the district court entered its final order granting the motion to suppress, the state filed a petition for writ of certiorari to the Court of Appeals. That was denied. The state then filed a petition for writ of certiorari to the North Carolina Supreme Court, and that was granted. As far as I know on this case, there was no transcript of the district court proceedings or record on appeal for the Supreme Court to review. I'm not exactly sure what they had to look at in making their ruling on this issue, but the Supreme Court found that it had discretionary authority to rule on the merits of the case and found probable cause. So, what does this mean? Again, my interpretation is if the state wants to appeal a district court judge's ruling on the motion to suppress, they can take that potentially all the way up to the Supreme Court if they want to force the issue that far. So more of a procedural question, in my opinion, versus the actual PC ruling on this. Again, I don't even know what the kind of overturning of a finding by the district court judge of a lack of PC was, since the Supreme Court did not have a transcript of the district court proceedings or really even a record to review. So I think that they were literally just looking at the district court's final order granting the motion to suppress. But again, my takeaway is that if the state wants to appeal a motion to suppress, they can kind of take it all the way up at some point in the proceedings to the Supreme Court if they want to push it that far. But obviously you gotta keep fighting. So Next category is kind of on the issue of expert testimony. This is based around the case of State versus Williams, 2023, unpublished opinion from the North Carolina Court of Appeals. I spoke about this case in particular, as well as State versus Lewis, back on episode 177 of the podcast. That was titled Post Hoc DRE Testimony. So if you have an expert testimony question, then that would be a good one to listen to. But the holding in this case is that it was not error for the trial court to allow a DRE to offer testimony about a DWI investigation in which the DRE was not initially or originally involved, when the DRE at trial stated that she could not testify, i.e., give an opinion as to whether the defendant was impaired. So basically, in Williams, there is no DRE involved in the original on-scene time of arrest investigation. Months later at trial, a DRE comes in and testifies, explains that she was not involved at trial, talks about some of the things that the charging officer observed, and then indicates very clearly, and I think, to some extent, at least candidly, that she could not give an opinion about defendant's impairment because she did not do an actual DRE evaluation at the time of arrest. So the question becomes, why is the DRE testifying? So, this is a case from Buncombe County, and I have seen the state routinely here call a DRE that has not done a real-time DRE evaluation on a particular case to give after-the-fact analysis and opinion at trial. The issue is that there is no opinion being offered as to impairment. Remember, and again, I said this on episode 177, but according to State versus Lewis, you can't give an opinion as a non-DRE under Rule 702. So the charging officer who's not a DRE can't give an opinion. The DRE can't give an opinion because they didn't do a DRE evaluation. And again, in State versus Williams, this 2023 unpublished case, the DRE very clearly says, I can't give an opinion about impairment because I didn't do the DRE evaluation. I cannot give an opinion about the defendant's impairment. So DRE is not giving an opinion. The charging officer is not giving an opinion. Nobody can give an opinion about the defendant being impaired. So again, I don't know. This is one of these ones where I want to pull my hair out because I just don't even understand what the state's argument is, where there's no officer that can give an opinion that the defendant is impaired, but you still end up with a guilty at the end of the day. Don't understand it. Go listen to episode 177 and really push this kind of argument forward that, look, Judge, in this particular case, because there wasn't a DRE involved at the time, nobody can offer an opinion about whether or not my client is impaired by an impairing substance other than alcohol. No DRE evaluation was done. Charging officer can't give an opinion. DRE can't give an opinion later. Go listen to episode 177 for further analysis on that. Next category is breath testing. This is a case from earlier this year that is a published case from the North Carolina Court of Appeals, State versus Forney. I did a full episode on this particular case earlier this year. That was episode 196. So I've done a full episode on this. So go kind of into the deep dive on that front. But briefly here, just to share the facts of that case, were that during chemical breath testing, the officer noticed the defendant had gum in his mouth and had defendant spit out the gum between the first and second breath tests, both of which resulted in a 0.11 BAC. The chemical analyst did not restart the observation period or seek an additional breath test, Both the state and the defendant had experts testify at trial on whether breath testing might be impacted by foreign objects in the mouth. Ultimately, the court held the provisions of the Department of Health and Human Services requiring an observation period by the chemical analyst were violated, and a new 15-minute observation period should have occurred after the defendant spat the gum out of his mouth before taking additional breath samples. Therefore, the results of the breath test should have been suppressed. The court ultimately found that the lack of suppression of the test was harmless error, which again, also one of those things you want to pull your hair out. Like if the test ticket getting offered to the defendant is not, prejudicial error, I don't know what would be prejudicial error in a DWI case. The court talked about some of the appreciable impairment evidence that was presented to the jury. But if you've got a test ticket 0.08 or greater that the jury sees in a DWI case, I just don't see how that does not constitute prejudicial error to have not suppressed that when the court says it should have been suppressed. But anyways, go listen to, again, episode 196 for the full story on that front. One thing that I talk about on there is how the court uses Henry's Law or points to Henry's Law. In this case, the court said, quote, the intoximeter estimates alcohol in the blood based on a measurement of alcohol in the breath, a ratio which in reality varies amongst different people by using a single specific ratio to standardize the testing of all subjects, end quote. So again, really good language on that front. If you have a case where you're trying to argue Henry's Law and that a breath alcohol concentration result is nothing more than an estimation of the blood alcohol concentration result. Why are we concerned with alcohol in the blood versus in the breath? Well, because you are impaired by alcohol when alcohol gets to your brain. How does it get to your brain? By getting into your bloodstream. Once it's in your blood, it gets in your brain, it's in your bloodstream in your brain, and that's when you're actually feeling that central nervous system depressant acting, is once it's in the brain. We don't care about how much alcohol you have on your breath in terms of is this person cognitively functioning or not. We care about it when it's in your blood, because when it's in your blood, it's in your brain. When it's in your breath, doesn't really make any difference. But breath is used to estimate blood alcohol concentration. So what is breath testing? Nothing more than an estimate of blood testing. That's what breath testing is. Important if that is an issue in your case. Great language from the State versus Forney decision on that front that could be used to further your argument at trial if that's an issue for you. Next category that we have is blood draws. So State versus Burris. This is an unpublished Court of Appeals case from 2023. It is currently on appeal to the North Carolina Supreme Court, so it's currently pending appeal. But in terms of the Court of Appeals unpublished decision, relevant facts are single vehicle accident, officer found defendant lying trapped under a steel fence outside of a vehicle that had sustained extensive damage. Defendant was unresponsive and bleeding excessively. The officer noted that the defendant smelled of alcohol and found beer cans both inside and outside the vehicle. The defendant was taken to the hospital, still unconscious. The officer obtained a warrantless search of defendant's blood while the defendant was still unconscious. Holding the court based on, according to the decision of the majority, Mitchell versus Wisconsin, U.S. Supreme Court decision from 2019 said that the exigent circumstances almost always exist to conduct a warrantless blood draw from an unconscious driver. I would point out that this opinion appears at odds with State versus Romano. Both Romano and Burris were Buncombe County cases. But if you look at the court's findings in Romano, you will see how closely these cases kind of seem to be to one another. From a law perspective, the difference is the facts. And so if you're trying to explain why Romano should apply in your case and why there isn't exigent circumstances, look at the decision in Romano to make that argument. Also, look at Judge Tyson's scathing dissent in Burris. Really a powerful, powerful dissent that can be helpful in crafting an argument explaining why exigent circumstances do not exist. So that is State versus Burris. Another blood draw case, State versus Russell, unpublished Court of Appeals opinion from 2023. The holding was that the confrontation clause is not violated where a substitute expert from the State versus Russell holding is that the confrontation clause is not violated where a substitute expert from the SBI testifies and is subject to cross-examination using another SBI agent's previously generated report, which otherwise may be inadmissible in forming an independent expert opinion. I don't think that this really changes much from what we have kind of looked at in the kind of recent case law landscape, but that is just a case from State versus Russell. In terms of the sufficiency of the evidence, that is also something that is addressed by State versus Burris, which we just talked about. So take a look at that case. There is another case in sufficiency of evidence, State versus Jones, which is a 2023 unpublished Court of Appeals decision. In State versus Jones, the facts were that the defendant admitted to being in a minor traffic accident. During the accident investigation, the investigating officer noticed an odor of alcohol in the defendant's car where he was sitting, slurred speech, and defendant admitted to drinking. Defendant blew positive on a PPT, showed 6 of 6 on HGN, and refused chemical testing after the arrest. The court held in the light most favorable to the state that the state had introduced substantial evidence that could prove defendant was appreciably impaired, and the trial court did not err in denying the defendant's motion to dismiss at the close of the state's evidence. So State versus Jones and State versus Burris are both sufficiency of the evidence cases from 2023. Finally, we get to kind of an update in terms of pretrial release, as well as kind of recent Knoll case, which I previously talked about on the podcast. But we had the Pretrial Integrity Act come out last fall in October of 2023. Basically, this act in part limits the authority of a magistrate judge to set pretrial release conditions for a person charged with DWI if the offense occurs while the defendant was on pretrial release for another pending proceeding. The act effectively allows only a district court judge to have the authority to set conditions of release for the first 48 hours. And the defendant, following the defendant coming into custody for an alleged DWI offense, if the defendant was on pretrial release at the time of the newly alleged DWI. So a change in the law. This seems to be at odds with State versus Knoll. So I think that I have seen issues in terms of how this has actually been applied or misapplied in real time, where it's not, should not have prevented the magistrate judge from setting conditions of release, and it in fact was. But I also think that it is substantively not square with State versus Knoll. And State versus Knoll, again, we've got a constitutional issue in terms of confinement coming at a crucial period in which the defendant can gather evidence on their behalf, and the opportunity to gather evidence and prepare a case in the defendant's own defense is a real right. And so that, you know, it's really not square with the language laid out in Knoll talking about the constitutional deprivation that results in prejudice to the defendant where there is this lost opportunity to gather evidence of sobriety or proof of sobriety. So be aware of the Pretrial Integrity Act, also State versus CKD. I, again, won't get too deep into this. This is a 2023 unpublished decision from the Court of Appeals. It is currently pending appeal to the North Carolina Supreme Court. I did a full episode on State versus CKD back on episode 191. An amazing opinion for the defendant. And so if you have a Knoll-esque case that you're currently arguing, again, go read State versus CKD. Again, it is currently pending appeal to the Supreme Court, but a very powerful opinion for the defense as it currently stands. Finally, we have kind of a couple of cases that deal with plea and sentencing. So 2023 published opinion from the Court of Appeals, State versus Harper. In that case, the court held that the trial court had erred by failing to arrest judgment on the defendant's conviction for DWI, as it was a lesser included offense of serious injury by vehicle, for which the defendant was also convicted. So if you have a situation where you've got a felony charge that includes as essential elements misdemeanor DWI, and your client is convicted of both, that opinion, State versus Harper, might be helpful at a sentencing hearing in terms of asking the court to arrest judgment on the misdemeanor DWI charge. Also, there's an unpublished opinion from this year, State versus Smith, from the Court of Appeals. In that case, the defendant brought what the court interpreted as the functional equivalent of a post-sentencing MAR, due in part to her attorney not advising her of the collateral consequence on her out-of-state driver's license. The court held in State versus Smith that this was not a problem. The court rejected the defendant's attempt to analogize her attorney's lack of explanation during kind of a conversation with the client about the collateral consequences of her license to an immigration collateral consequence addressed by Padilla versus Kentucky. So didn't find that this was the same level as that kind of lack of appropriate advising on collateral damage when it comes to deportation being a possible end consequence. So again, maybe something to consider. I would just maybe say as a final practice tip that kind of goes on this front, for any client with an out-of-state driver's license, you might want to refer them to an attorney in the client's home state to discuss licensing consequences. One place that you can do that through is the member directory of the National College of DUI Defense. That might be a good reference point. So that is that's the 2024 DWI update. Again, as any kind of big cases come down the pike that have a DWI impact on North Carolina legal framework, we will talk about those individually on the podcast moving forward. So hope this information has been helpful to you, and I look forward to speaking with you again next time.